Hi, my name is David Holt, and this is the screencast for Advanced Legal Research and Intellectual Property, the week dealing with trademarks. Once again, we're going to start with a very broad, very quick overview of the trademark legal schema. First, some basics as to what constitutes a trademark. Trademark law protects marks that distinguish goods or services of a manufacturer, merchant, or service provider. Typically, these can be logos or brand names, but trademark law can also protect more esoteric items, including colors. So, for example, the brown used on the UPS truck is actually a color that qualifies for trademark protection. Likewise, sounds, product packaging, or design features can be protected under trademark law. Trademark law is a little different than the other areas of intellectual property law that we've already worked on this semester. First, it's a subset of unfair competition rather than grounded in the copyright and patent clause of the Constitution. So when Congress enacts legislation dealing with the protection of trademarks, they are doing so in the powers given to them under the Commerce Clause. The courts, for a very long history, from 1860 up until the 1940s, held that Congress could not create federally registered trademarks as this exceeded their authority given to them in the Commerce Clause. Congress revised some of the proposed statutes, and this was finally rectified with the passage of the Lanham Act in 1946, which is our modern federal trademark legal schema. Okay, there still is common law protection for trademarks, and this is true for both federal and state law. Trademarks that are used in commerce may acquire rights without requiring registration. Registration, however, provides a number of benefits. For one, it's presumption of validity, access to remedies, including access to the federal courts, and etc. The strength of a trademark is based on 4 categories of distinctiveness, and these are in order from most distinctive to least distinctive and generic. And so arbitrary and fanciful are the strongest marks. They are some examples here include Exxon, Kodak, Xerox, and Buick. They're not suggestive in terms of the product or services that are being sold, nor are they descriptive. They are arbitrary and fanciful. Suggestive marks come after that. PlayStation is a nice example here. It suggests the type of product that it is. Descriptive then follows, and then generic does not receive any protection. So generic marks that are not descriptive, suggestive, arbitrary, or fanciful receive no protection as trademarks. Some of the factors that are considered in an allegation of infringement include the strength of the mark, the similarity between the two marks, evidence of actual consumer confusion, the defendant's intent, whether he or she acted in good faith, consumer sophistication, and competitive proximity. So if the two producers are competing within the same geographic location, that is also a factor. Okay, from that, let's dive into some of the major resources that you will utilize in doing research projects involving trademarks. The first big resource here is the USPTO's website. The USPTO's website can be used to register for trademarks online, and you can also search for trademarks that have already been registered through a system called TESS. You can also access decisions from the Trademark Trial and Appeal Board and propose regulations, agency documents, and etc. If we take a look at the USPTO's website here, you can see that you can search the trademark database, which is the Trademark Electronic Search System, or TESS. You can also file online, check the status of any filings. You can access primary materials, both statutory law and regulations that have been proposed and adopted by the USPTO. And you can locate decisions issued by the Trademark Trial and Appeal Board. And just like the Appeal Board for patents, this is the administrative adjudicative body that decides if there are trademark interferences, if you have a third party that's challenging the registration of a trademark, if a applicant has applied for a trademark that has been denied, this is the remedy that they need to utilize. Once the administrative remedy has been exhausted and the board has issued their final decision, that decision can be appealed to an Article III federal court, just like decisions from the Patent Appeal Board. Also on the USPTO's website is the Trademark Manual of Examining Procedure, which is also TMEP. It gives the framework as to how trademarks are examined by the USPTO to give guidance to applicants. They also produce a weekly gazette, which is a list of approved trademarks, and again the Trademark Manual of Examining Procedure, TMEP, which is available through the USPTO's website. It's also available in the practice materials that we're going to discuss in just a second. The first being McCarthy on Trademarks and Unfair Competition. This is a major treatise that deals with trademarks and unfair competition that's available on Westlaw. It will include USPTO rules, legislative histories and documents related to trademark law, examination guides, including the TMEP manual, and a table of statutes and cases. If we go into Westlaw here and click on intellectual property, and then all secondary sources, and then text and treatises, you can see under trademarks that we have Coleman on unfair competition, trademarks, monopolies, which is another practice set that's similar to McCarthy. McCarthy is also available here, and then a number of forms, and then international trademark practice, and Trademark Trial and Appeal Board practice and procedure. Likewise, on Lexis, there is a corollary practice set, which is Gilson on trademarks. It's a larger set compared with McCarthy, and it's also more practice-oriented than McCarthy. It includes drafting tools and forms. And so if we go to Lexis here and click on Browse, and then Sources, then by practice area, and then scroll down to Trademark Law, you'll see that Gilson on trademarks is available here. If we click on the table of contents, you'll see that it includes TMEP, also the Appeal Board Manual of Procedure, some primary materials, and so the Lanham Act, the actual statute, sections from Title 33 of the Code, some uniform laws. But you'll also have here in Part 2 your forms and drafting guides. And so these are particularly useful for actual practice, and that's rather extensive compared with McCarthy. In addition to those practice materials, you need to stay abreast of developments within your practice area, and one of the major sources for that, particularly as it pertains to trademark law, is BNA's Patent, Trademark, and Copyright Journal. Now, I recommend the BNA newsletters not only for IP, but the others that are available here on Bloomberg. Let me show you some of the major ones. If we click on, we're here in Bloomberg, and if we click on BNA Law Reports, and let's sort this by title. Okay, so the Patent, Trademark, and Copyright Journal. There is a print edition that comes out every week. Let's try that again. I'm having problems. There's a print edition that comes out every week, but there's also a daily edition, and it includes developments in patent, trademark, and copyright. It's an invaluable source for staying current within intellectual property. In addition to the intellectual property newsletter, one of the very big ones here is United States Law Week, which you should be familiar with if you're not already. U.S. Law Week will publish slip opinions from the U.S. Supreme Court. It will note circuit splits. It's a widely read current awareness tool. If you have any questions about this week's assignments, I have been very pleased with what I've received so far on the novelty toothbrush problem for our patent law week and our patent law exercise that preceded that. For trademarks, we have a Yosemite National Park exercise that I would like you to complete. And this is a discussion forum assignment. I want you to create a research memo on whether the USPTO should nullify the trademarks at Yosemite Park, and to provide some secondary materials and primary authority as appropriate for that. And then for the other assignment, dealing with the disparagement clause, it is a case that is currently petitioning review by the U.S. Supreme Court, which is a First Amendment argument that the disparagement clause within the current U.S. Code violates free speech protections. Again, if you have any questions about this week's assignments or the previous weeks, please don't hesitate to contact me. You can always reach me via email.